Hello everyone, this is Cheenu Sharma. So welcome back to our second lecture of NCA Professional Responsibility. So today we are going to start with part B, Ethics, Lawyering, Professional Regulation. In this we are going to cover first two topics, lawyer-client relationship, then how we have to preserve the client's trust confidence. So the preservation of client's confidence. So firstly, let's look into what syllabus talks about. So this section of course addressed the general role and responsibility of lawyer that arise in many and in some cases all aspects of practice of law. Next part examine the obligation of lawyer in some specific practice context. So lawyer-client relationship. How does this relationship come into existence? What kind of agreement do we need? Then what are the choices that are available to lawyer with respect to accepting clients? Can a lawyer accept all clients? Is he or she obliged to accept all clients? Then what significance for lawyer and client is the existence of relationship? How important is this relationship? What obligations for lawyer arise as a result? Basically, what are the lawyer's responsibilities towards the client? Then what are the motivations of lawyer? Techniques they use. Can they do marketing? Is advertising allowed? Then are all these motivation techniques appropriate? What larger values do they advance or undermine? What circumstances, conditions lead to termination of relationship? This lawyer-client relationship. What are the implication, result for the lawyer after termination? What are the things that are available to a client? Next is how to preserve confidentiality. Confidentiality means secrecy, the trust that has been shared by a client with the lawyer. So what are the basic confidentiality obligation? Where does this obligation come from? Source. What is the difference between confidentiality and privilege? And are there any exceptions exist where a lawyer can do away with this confidentiality? So what are those conditions? So we'll be talking about everything in detail today. Firstly, number one thing, from where a lawyer client relationship starts. So model code defines the word client. So it says 1.1 says a person who consult the lawyer, on whose behalf lawyer renders or agrees to render legal services. Simply a person who consults the lawyer related to any legal matter, and thereupon, based on that consultation, when a lawyer represents that person, gives, render or agrees to give his legal services, or having consulted the lawyer has reasonably concluded that the lawyer has agreed to render legal services. It means reasonably concluded means you have agreed upon certain things. There is a agreement. So if a lawyer is consulted by a person and the lawyer provides or agrees to provide legal advice to that person, from here lawyer-client relationship exists. So you have to keep in mind the word here is provide or agrees to provide. There should be certain kind of certainty. In simple terms, there should be certain kind of reasonability, foreseeability from the conversation, from a general consultation. One can clearly figure it out that okay, there exists certain kind of relationship. Like for example, you are meeting a lawyer at a lawyer's office or in a less formal or non-business environment does not matter. If no legal services have been rendered and the lawyer did not agree to render any legal service, then the lawyer will need to observe the facts of the circumstances in order to determine whether there exists any client lawyer relationship or not. So the key issue for determination whether there exists a lawyer client relationship is whether it is reasonable for the person to conclude that the lawyer has agreed. There must be certain kind of affirmation agreement on part of the lawyer that okay, I am ready to render my legal services on your behalf. So there was a case which talks about lawyer client relationship, Descartes versus Merz-Winske, 1982. So what was the background of the case? A citizen visited legal aid office, completed an application for legal aid form. Police subsequently requested documents from the legal aid office, including the application form. So the issue was whether the form that the person filled was protected by solicitor-client privilege, indicating there exists some lawyer-client relationship. If so, when this relationship was formed. So Superior Court decided that the lawyer-client relationship and right to confidentiality were deemed to arise only when this application of legal form was accepted by a certain lawyer, essentially when the retainer agreement was established. Till the time this is only in the form of an application, there is no agreement on part of a lawyer. The lawyer-client relationship does not come into existence. So Supreme Court of Canada determined that the lawyer-client relationship begins as soon as the potential client initiate contact with the lawyer's office to seek legal office. This initiation of contact constitutes the establishment of relationship irrespective of whether the retainer has been formally agreed upon. The amount of information provided by potential client during his initial contact is deemed sufficient. Basically, when you go to a lawyer's office, you visit him, you provide your information. There is a consultation. So at the very first meeting, when you initiate your contact, so from that very particular point, your relationship begins. Even administrative information provided during initial contact is relevant to the establishment of professional relationship. Such information may also be highly confidential and would have been kept secret by prospective client if not for the need of legal service. So what's the significance of this case? So this case clarifies that regarding issues of confidentiality, a solicitor-client relationship is formed at the moment client initiates contact as lawyer's office. The moment a person reaches lawyer's office, share basic information, no matter even if it is administrative information, certain name, address, background of a person, every such information is protected as per lawyer-client relationship. Therefore, any communication arising from this interaction, as I told you, protected by solicitor-client privilege, regardless of any formal agreement, formal establishment of a retainer. So in this case, no matter the person has not contacted any particular lawyer, as the Superior Court said, but Supreme Court clarified the position. Choices available with respect to accepting client. So engagement letter, retainer agreement, money retainer. These are few agreements that comes into existence once a lawyer-client relationship has been established. Lawyer should confirm in writing whether they will act for a client who has consulted with them. So for this they have few agreements: retainer agreement, engagement letter, non-engagement letter. It is important for a lawyer to clearly communicate, to clearly tell, to clearly establish when they have or have not been retained for the purpose of legal services. This should be confirmed in writing to avoid any confusion. Engagement letter assist in setting expectation, reduce scope creep, and help reduce risk. So once a lawyer-client relationship subsists, once you have established the relationship through a particular agreement, you have clearly told your client in writing that okay, I will be rendering legal services on your behalf. Then what happens? So then certain duties comes into picture. So firstly, a lawyer has a duty of competence. A lawyer must perform all legal services as per Model Code 3.12 undertaken on client's behalf. Whatever you have been agreed here that okay, I will be providing you these all services, a lawyer must try to give his or her best to the client. So standard of competent lawyer should be established. A lawyer has then duty of honesty and candor. Frankness 3.2 talks about this when advising a client. A lawyer must be honest, candid, must clearly state all the important information known to the lawyer to his or her client that may affect the interest of the client. Then, lawyer has the duty to fulfill all undertaking given to the client. A lawyer's undertaking is their personal promise, responsibility. Next, these cases mentioned hereinafter highlight the potential for lawyers to owe trust duty. Fiduciary means trust to third party in certain circumstances, even when those parties are not directly represented by a lawyer. So there are few situations where a lawyer has a duty of trust fiduciary to a third party. Like in the case of this Tracy Atkins, BC Supreme Court established that a purchaser's lawyer in a real estate transaction owe fiduciary duty to vendor, particularly if they were elderly unrepresented. So court ruled that lawyers should have recognized that the vendors might rely him to protect their interest, leading to the imposition of fiduciary duty. So for example, you are representing a big company, a big real estate corporation. So you have one client that is the owner, but indirectly all those people who have interest in that real estate property, in that particular building, you owe a fiduciary duty to all those people as well. No matter they are not directly your clients, but indirectly they are third party, you owe a fiduciary duty. Next is Shopper's Trust Company case. It was determined that a lender solicitor has a fiduciary duty to ensure that borrower's spouse receive independent legal advice if they are unrepresented, unfamiliar with legal matter. So this obligation arises from lawyers' position of trust, expertise, which may extend to protecting the interest of parties indirectly, as I told you earlier, whosoever, if somebody's spouse is indirectly involved, then it's a lawyer's duty to make sure that that particular person is also represented. So in terms of the other two subjects of our syllabus, advertising and when does a conduct become inappropriate, marketing, so we will refer to the advertising part further. So before moving further with our advertisement marketing points, firstly let's look into the basic duty of a lawyer to act as an advocate. So lawyers must represent clients resolutely, honorably within the limits of law, while treating the tribunal with candor, fairness, courtesy, respect. So lawyer must act honorably with integrity, honesty. So this is the first thing. So lawyer should act as a neutral agent whose responsibility is to represent client but without anything unethical, must preserve the morality of client's action and behavior. So as per Simon, these are few scholars who have their different views related to lawyer as an advocate, that what how a lawyer should advocate, how a lawyer's action should reflect while representing his client. So lawyer should take those actions that seem to most likely promote justice. Lawyer must be partisan, advocate for his client's end. They suggest taking a middle ground between two extremes. So ignore the morality of client and do your job, only represent client whose beliefs and morals align with you. Hutchinson believes it is important to speak with potential clients first, feel them out to determine their basic expectation. He suggests informing them of ethical constraint. So here what we can figure out is that at every step morality comes into an existence. So everyone is suggesting that okay, sometimes there is no need to just go by morals. You have to represent your client as in the best manner possible, but do as per your own morals. If not as per client's morals, do as per your own morals, which include basic integrity, honorably, then dignity, courtesy, fairness in the court of law. So this is how a lawyer's duty comes into picture as an advocate. So for the last part of our first topic, we will be talking about later under termination of client. Before that, let's look into few important things. Advertising. So, marketing of professional services, Model Code 4.2 talks about this. They say marketing must be demonstrably true, accurate, nothing fake, nothing faulty. You can't market. It should not be misleading, confusing, deceptive. It should be in the best interest of public. High standard of professionalism should be reflected from your marketing. Then advertisement fees. Fees advertised must be reasonably precise. Any additional charges should be clearly stated. Advertised fees, a lawyer's fees must be strictly adhered in all applicable cases. Whatever fees you are advertising, you should make sure that you are charging that fees only from your client. Advertising nature of practice. So this is barred. You cannot do this. 4.3 Model Code says lawyers must not advertise as specialists in the field unless certified as such by society. You cannot say that, okay, I'm the best lawyer, come to me. This is barred. Law Society of Saskatchewan versus Merchant case, Mr. Anthony Merchant sent unsolicited letters to several potential victims of Canada's residential school scheme. In these letters, he informed recipients that he represented individual organizations suing government churches for abuse. Letters suggested potential recoverable amount included assignment and retainer agreement. So the lawyer himself sent few unsolicited letters to the victims of a scheme. In those letters, he suggested few amounts, recoverable amounts, and retainer agreement to keep that lawyer as their lawyer. So letters also stated that recipient had nothing to lose, would pay nothing if no recovery was made. But if recovery occurred, then in another sense, if they won the case, then merchant would receive that recoverable amount's particular portion as a fees. So recipients were asked to provide their reflection on their experience in the school and return the authorization form. One recipient B complained Saskatchewan Law Society alleging that unsolicited nature of letter, their misleading structure create unjustified expectation. While Merchant was acquitted of creating unjustified expectation, he was found guilty of misleading conduct because here he is indirectly charging a fees. As I told you in the last slide that your marketing, your advertisement should not be faulty, confusing. You cannot mislead any person. So here in this case, the lawyer Merchant was found guilty of misleading conduct because the letters were deemed misleading because they failed to acknowledge the possibility that recipient might not have a certain legal claim. Merchant was also found guilty of conduct unbecoming a lawyer for engaging in undignified marketing activity. He himself went to all the victims through unsolicited letters. Then he tried to gain their interest by suggesting them something misleading. So he was again number two guilty of becoming an undignified lawyer by doing undignified marketing activities. So sanction against Merchant was upheld by majority of Saskatchewan Court of Appeal and his misconduct was affirmed. So this is how he conducted something that was not justified. Then what about fee sharing? We talked about advertising. To what level it is allowed. Related to fee sharing, as per Model Code 3.67, lawyers must not share fees with non-lawyer or give rewards for client referral. So if someone is bringing client to you, you are not legally allowed to pay that person any kind of fees for client referral. Referral fees between lawyers are allowed if reasonable, but that should be disclosed to client and it should be with client's consent. Then exception for multidisciplinary practices and interjurisdictional law firm. Multidisciplinary practice and interjurisdictional firm have exception to fee sharing rule based on their own partnership agreement and how their firm structure is. Then solicitation. So solicitation must balance informing individual of legal services with respect to privacy, avoiding exploitation of vulnerable person. Ethical concern arise with advertising legal services in sensitive environments like hospital. here in these areas, if you're soliciting your legal services, it's very inhumane, it's very unethical. Legal society regulates solicitation to ensure ethical conduct and protect vulnerable individuals. So solicitation is only allowed as per the particular legal society's rule. Then lawyer must possess and apply relevant knowledge, skill, attribute appropriate to each client matter. Clients are entitled to expect competent representation. As I told you in the beginning, that's your duty to give your best to the client, to provide quality of service. Then when does the lawyer-client relationship terminates? So lawyer-client relationship may end through completion of the retainer or withdrawal by either party. When your retainer agreement till the time you agreed for the representation of particular lawyer for a lawyer to render his or her legal services, when that retainer agreement is complete, then automatically the lawyer client relationship comes to an end, or when one party withdraws. So termination require communication either through closing letter or withdrawal notice. So this is a way. Lawyers must have justifiable cause. If any lawyer withdraws, then lawyer must provide a reasonable notice plus reason, cause, justified reasonable cause to the client. Obligatory mandatory withdrawal occur if discharged by client or if client persists in unethical instruction. Then if client says lawyer to do something illegal, then automatically withdrawal occur. It can also occur if there is a serious loss of confidence between lawyer and client, or if there is a non-payment of fees on part of client. So for this non-payment of fees, we'll talk about later. There are certain conditions related to it. It's not always that on non-payment of fees, a lawyer can always terminate a relationship. Regulatory rules outline condition procedure for withdrawal, ensuring ethical conduct, protecting client's interest. So this is the case, important case. So in R versus Cunningham, what happened? Counsel applied to withdraw representation for an accused. What were the grounds of withdrawal? Accused was suspended from legal aid, unable to pay legal fees. Issues: whether a court has authority to refuse defense counsel request to withdraw due to accused non-compliance with financial term, whether oversight of lawyers' withdrawal falls exclusively to law society. So court had to decide whether they can refuse counsel's request to withdraw to accused case when the accused has not paid particular legal fees. Supreme Court of Canada held that a court can refuse to grant the request to withdraw when the reason is non-payment of fees. So if the reason is just non-payment of fees, there are cases where the court says counsel the lawyer to continue representing. However, this authority must be exercised sparingly only when necessary to prevent serious harm. So if the court sees that, okay, if the lawyer is not going to represent this person just because he is not able to pay legal fees, there would be serious harm to administration of justice. Only in that case the court steps into this thing. Otherwise, the court grants permission. Requiring counsel to continue against their will would be inappropriate if it violates professional responsibility. Oversight of lawyers' withdrawal is not exclusive to law society. Both courts and law society have distinct but important rules. So what are the guiding principles? So if withdrawal is requested well in advance and won't require adjournment, it should be allowed. So this happens usually. But if timing is an issue, then court will inquire into counsel's reason. If withdrawal is due to ethical reason or non-payment of fees, the court should accept counsel's answer without any further inquiry. If withdrawal is sought for ethical reason, it must be granted. If due to non-payment, the court may refuse if there is, as I told you earlier, serious harm to administration of justice. So basically, the cases where the withdrawal is because of any illegal thing that client asked to the lawyer, then usually the court grants permission to withdraw. But if the reason is only non-payment of fees and that thing could harm the administration of justice, then there might be cases where the court won't grant permission to the counsel to withdraw representation. Next is optional withdrawal summary. So in ordinary simple proceedings, what happens? A lawyer can withdraw for good cause, must provide reasonable notice to the client, must inform the client way in advance. So what could be good cause? It could be serious loss of confidence as per rule 3.7, non-payment of fees. Reasonable notice should be determined based on specific circumstances. Then withdrawal is permitted if there is a good cause and interval between withdrawal and trial. So if you think that okay, between the trial and withdrawal there is sufficient time that the client can engage some other lawyer, there would be no harm to justice, there would be no harm to administration of justice, then sometimes the good cause thing survives. So it includes serious loss of confidence, not payment of fees, then interval is sufficient. If interval is sufficient, withdrawal for good cause is permitted. If it is not, then withdrawal for non-payment is not allowed. This is again same exactly what came out in R versus Cunningham case. So all those principles same. Withdrawal for good cause may be permitted with court's approval. Then leaving a law firm. Rule 3.778 talks about this. Responsibilities of departing lawyer and a firm. So if a lawyer is leaving a firm, he must ensure that clients with current matters involve the departing lawyer are given reasonable notice that this particular lawyer which has been representing you is going to depart, is going to leave our firm. So the client should be informed about this thing way advance. Advise affected clients of their option for retaining counsel. So you can tell the law firm can ask the clients that if they want to retain that counsel outside our law firm in his or her personal capacity, then okay, you are free to do so. Obtain instruction from each affected client regarding the choice of representation. Clients' interests are important, paramount. They should be allowed to freely decide whom to retain as counsel. Clients should be provided sufficient information to make decisions about their legal representation option. What's the manner of withdrawal? So, withdrawal should aim to minimize expense, avoid prejudice to the client. Whenever a lawyer is taking a decision to withdraw, he or she must make sure that his withdrawal would cause minimum prejudice to the client, minimum harm. Effort should be made to facilitate an orderly transfer of the matter to successor lawyer. So usually what happens? The law firm make effort that things go smooth and the case transfers to the new successor lawyer. So rule 3.79 talks about responsibilities upon discharge or withdrawal. So whenever there is a discharge or withdrawal, firstly the lawyer should notify the client in writing, including reasons if applicable, inform client involved in litigation about expected proceeding, then need to retain new counsel immediately, promptly, deliver all the paper or property, all the information that was with the lawyer which is related to client, provide all relevant information related to case, account for all client funds, refund any unearned remuneration, promptly, immediately render an account for outstanding fees, disbursement. Cooperate with the successor lawyer to transfer the file efficiently, provide all the related information to the new successor client so that there won't be any expense prejudice to the client. Comply with applicable court rules. So next topic is preservation of client confidence. How you're going to keep, preserve, protect your client's trust. So lawyer has a duty, responsibility to preserve confidence of his or her client. So there are few views of different legal scholars. Firstly, Prowls versus Layton. They state that justification for imposing duty of confidentiality is that a client who is assured of complete secrecy is more likely to reveal to his or her counsel all information pertaining to the case. To sufficiently serve a client, a lawyer must have all pertinent information. So basically, they say that a lawyer should bring so much trust before the client that the client share all important information that are relevant to the case, because a client will be comfortable in sharing all important things, all secrets, only if he or she thinks that the lawyer is trustable. So individual will not freely offer information if they are not satisfied that the lawyer will keep that information confidentiality. So this satisfaction duty is upon lawyer to build. So preservation of client confidence, maintain confidence of public in legal profession. In limited but important circumstances, protection of client confidence may yield to greater public interest. As per Lamer J. in Descortex case, it is a personal and extra patrimonial right which follows through a citizen through dealing with other. Like other personal extra patrimonial right, it gives rise to preventive or curative remedies provided for by law depending upon the nature of aggression threatening it. A lawyer who communicates a confidential communication to other without client's authorization could be sued. So charges could be laid against that lawyer if he or she communicates the confidential communication shared by client to any other party. So to a third party who had accidentally seen the content of lawyer's file, all these things are prohibited. So lawyer cannot do anything that can harm the confidentiality. So now what's the status within law firm? So expansion of confidentiality obligation within law firm. So in R versus Neil, Supreme Court of Canada established that confidentiality obligation extend beyond individual lawyer, and this confidentiality duty applies on a complete whole entire law firm. Both individual lawyers and firm as a whole owe fiduciary duty. So no matter you are an individual lawyer, but your whole law firm also simultaneously owe a fiduciary duty of confidentiality to lawyer. So no matter you had any previous former client, it's your duty to protect the information of your former client for all the times to come. Lawyers within the firm are prohibited from using confidential information against former client. This ensured that past client information remain protected even if they are no longer actively represented by the firm. So this means if you had a client and that client somehow for any reason changed the representation, now is representing by a new client, and that former client is now the second party, the opposite party for your current client. So it does not mean that now you are going to use all those confidential information that that client shared with you previously being your client. So this you cannot do. So always you have to protect your client's information. So former client's information can never be used against current client's information. So this is the key, and in examination many times you get questions like this. Then transparency during firm transition. When a lawyer changes firm, for example, I work in a law firm A and now I am changing law firm. I'm going to law firm B. So there is an assumption that they may share confidential information about past client with members of new firm. So proper screening measures should be taken place, must be implemented to prevent the unauthorized disclosure of confidential information. What's the difference between confidential and privilege? So basically privilege, confidential we know, secrecy. Privilege comes being a lawyer from that position. So it is an evidentiary rule of law that refers to legal right of a person to withhold information from opposition, court, tribunal, investigation. Each is based upon principle that lawyer owes a duty to client. So this is the privilege of a lawyer-client relationship, that your information will never be disclosed by lawyer to any other party. So lawyer has the duty to maintain client confidence. Nonetheless, the scope, application of all these duties are different. So two main differences between confidentiality and privilege. Confidentiality, ethical principle versus lawyer-client privilege, it is legal duty. So lawyer-client privilege is something that is legally expected from a lawyer to do. Confidentiality, secrecy comes from morals. This is your personal choice. This is your ethical duty. So confidentiality is much broader. It pertains to all information obtained by a lawyer during the course of retainer. Privilege, all information concerning the business and affair of client acquired in course of professional relationship, whatever is directly related to the case. So it is limited to private communication between lawyer and client. What's the difference? So difference is that while all communication between a lawyer and client are confidential, but all communications are not privileged. Are not privileged means all communications are not such that they cannot be bring forth before the court. So they would be protected from disclosure in a lawsuit. So what are the protections for solicitor client privilege? So Supreme Court recently affirmed in Ontario Public Safety Security versus Criminal Law Association case that a solicitor client privilege is a fundamental substantive rule of law given the prominence to public interest in maintaining a trusting solicitor client relationship. Nonetheless, it is important to understand that there are constraints. There are few exceptions to this privilege where the communications are not protected. So whenever something is illegal, something unethical. So those things the lawyer is not obliged to keep secret. So there are limited circumstances where solicitor client privilege will not apply. For example, communications must be shared due to clear, serious, imminent threat to public safety. So for example, a person is coming to you, he's your client, and he's saying that tomorrow I am going to destroy whole nation. So this is something which is a serious threat, immediate threat to public safety, and a lawyer must disclose that information. So, or where the lawyer must disclose limited information about client to defend herself from allegation of misconduct. In such instances, a lawyer may be permitted to waive privilege. So as I just told you the example, so in these cases, a lawyer is allowed to waive this privilege. Therefore, although most communication between client and counsel will never be exposed, it is important to comprehend that confidential nature of solicitor-client communication is not sweeping, is not absolute. So there are certain cases, certain areas where you can do away with this privilege. So Model Code. Model Code 3.3 says that a lawyer at all times must hold in strict confidence all information concerning business affair of client acquired in the course of professional relationship, must not divulge any such information unless expressly impliedly authorized by client to share that information. It is required by the law or court to do so, then required by law society, otherwise permitted by rule. So this rule must be distinguished from evidentiary rule of lawyer and client privilege, which is also constitutional protected right concerning oral documentary communication. Whatever happened between a client and lawyer, all those things comes under the client and lawyer privilege. Ethical rule is wider and applies without regard to nature and source of information. So confidentiality is much bigger than privilege. A lawyer owes duty of confidentiality to every client without expectation and whether or not the client is continuing or casual. Duty survives the professional relationship continues indefinitely after the lawyer has ceased to act, as we discussed earlier. So this commentary is just summarizing all those things that no matter a particular person is your former client, it's your duty to keep the information confidential. So M. Proggs versus Layton, Ethics and Canadian Criminal Law. In this, they said that customary and prevailing reason for imposing a duty to confidentiality upon lawyer is that client who is guaranteed of complete secrecy is more likely to divulge all information, as we discussed this thing in the very beginning as well. So privilege is a notion developed by the courts. Privilege only applies to communication between client and lawyer. So these are only communications, privileges, and confidentiality is everything, including the administrative information from the very first day when the lawyer came for your consultation, everything. So privileges are only the legal things that you are obliged to keep secret. So in Pritchard versus Ontario Human Rights Commission, for solicitor-client privilege to apply, the party asserting the privilege must establish that communication meet the following criteria. So firstly, the party has to prove that the communication was between solicitor and client. It must entail seeking legal advice. The advice sought must be intended to be confidential, that they particularly discussed with each other that okay, this particular communication will be kept confidential. So Woolley says to be privileged, the lawyer-client communication must be made for the purpose of legal advice versus any communication in the course of professional relationship attract the lawyer's ethical duty of confidentiality. So again, simply whatever is a legal advice between a lawyer and client, any documents, anything, that is a privilege. But whatever communication, legal, non-legal, ethical, moral, general, so all those things are confidential. So confidential is a broader thing, wider thing, and this privilege is a narrower thing, and it has few restrictions, exceptions. So first, very important, in this case a lawyer is not obliged to keep things confidential. So crime fraud, this is first exception to this privilege. So Descotex versus Merzwinski case. So this case we talked about earlier as well. Definitely lawyer-client relationship here arises from the very first application that the person signed, that the person filled for the legal aid. But here the person, he fraudulently obtained legal aid by lied about his financial terms. So here what happens? The exception arises. So the court said that okay, there is no doubt that the documents would normally be protected by the solicitor client privilege but ultimately unprotected because they were themselves criminal. This person lied about financial means in order to obtain legal aid, so this is not protected. So there are a few other cases that you can refer from the notes. Next is public safety exception. As I gave you example that a person comes to you and says that okay, tomorrow I'm going to destroy the whole nation, so you have to represent me, or there is something related to aggravated sexual assault, you think that the person is continuing danger to the public, then in these kind of cases a lawyer, a solicitor client privilege can be ruled out. So let's look into this case of Smith versus Jones. Solicitor client privilege is claimed for doctor's report. Appellant Jones was charged with aggravated sexual assault of a prostitute. He was referred to a psychiatric. Responded Smith. John's counsel advised him the consultation was privileged in the same way it with the lawyer. Dr. Smith found Jones posed a continuing danger to public because of the conduct. Told defense counsel that in his opinion it was probable and likely that the accused would commit offense in the future. So after learning that the judge would not be advised of his concern, Dr. Smith sought legal advice, commenced his action for declaration that he was entitled to disclose information he had in his possession in the interest of public. So he filed an affidavit describing his interview with Mr. John's opinion, and doctor said that I think that this person is a continued danger to the public. So issue is whether Dr. Smith is able to violate doctor-patient solicitor-client relationship, and he can disclose confidential information of accused to protect the public from harm. Does it meet disclosure requirement? So what was held? Solicitor-client privilege is a principle of fundamental importance to administration of justice. This is highest privilege. So it's generally said that to whom else you will share your thing if you are not safely allowed to share your secrets, your whole information with a lawyer. But in Canadian law, these things have few exceptions. So in this case, the privilege is claimed not for the client conversation with lawyer, but those with the psychiatrist whom his lawyer retained as an expert. So tradition and case law support the extension of his privilege to include communication, conversation otherwise between accused expert in the same way. So this client privilege extends to the third party as well, whom the lawyer has included as an expert. Despite significant weight of the principle of solicitor-client privilege, the privilege is not absolute. We are saying this thing again and again. There are few exceptions, and here the exception is public safety. So there are three factors that you should keep in mind when determining if public safety outweighs, is more important than solicitor client privilege. Number one, if there is a clear risk to an identifiable person, group of person, if that risk is of serious bodily harm, if the danger is imminent, unavoidable, immediate. So these factors have to be applied from case to case basis. Then seriousness of the matter has to be seen, imminence factor has to be seen. So here in this case, the solicitor client privilege was set aside, keeping in mind that public safety outweighs this privilege, because any reasonable observer, given all these facts, given all this situation, will say that there is potential danger posed by the accused, and this danger is clear, serious, and imminent. Third is if someone's innocence is at stake. So R versus Macular case, respondent M was librarian and teacher at a school that the appellant attended. M was charged with sexual offences against 11 former students. Appellant provided a statement to police regarding sexual touching by M. This statement was added to indictment against M. Appellant initiated a civil claim against M. M sought production of civil file to assess and determine the nature of allegation. So here issue is, should solicitor-client privilege of another be invaded in favor of accused right to make full answer in defense? What is the appropriate test to use for determining when the accused right to full answer and defense override another solicitor-client privilege? So what held in this case was, solicitor-client privilege is a principle of fundamental importance to administration of justice. Despite its importance, again here, this privilege is not absolute. When someone's innocence is at stake, we can do away with this privilege. So, in limited circumstances, may yield to allow an accused to make full answer and defense. Appropriate test for determining whether to set aside this privilege is innocence at stake test. Test is a stringent one. Privilege should be infringed only where core issues going to the guilt of accused are involved. There is genuine risk of a wrongful conviction. So when there is a genuine risk of wrongful conviction, some innocent person is at danger of getting imprisoned, getting convicted, then we can do away with this privilege. So here the trial judge erred in using the O'Connor test for production of third-party confidential therapeutic record to govern whether the litigation file should have been produced to the defense. The test includes two steps. First step, providing evidentiary basis that demonstrate that communication could raise a reasonable doubt to accused guilt. So where the solicitor-client communication can reasonably raise doubt on accused guilt can protect some innocent party, then secondly, the judge must ask, is there some evidentiary basis for the claim that the client solicitor communication exists and that this could raise a reasonable doubt about guilt? So, if in some cases there is some kind of communication between a client and a lawyer, and that communication, if come before the court, can protect some innocent person from being held guilty, then you are allowed to bring that communication before the court. So if the judge is satisfied that there is some evidentiary basis exist, we can proceed to the second stage. At this stage, the judge must examine, assess the record, inquire is there something in the solicitor-client communication that is likely to raise reasonable doubt about the accused guilt. Then if the second stage of test is met, the judge should order production, but only that portion of the file that is necessary to. So again, there are few additional extra cases that I have mentioned in the notes. You can follow those. Fourth is legislative exception to confidentiality and privilege. Parliament provincial legislature has introduced provision that set aside clients' right to confidentiality. So there is a case of Goodies versus Ontario Ministry of Correctional Services 2006. In this, what happened? A journalist applied for access to all record pertaining to allegation of sexual abuse of offender by probation officer employed by Ontario Ministry. So Ministry of Correctional Services claimed solicitor-client privilege with respect to all relevant documents. What happened? What was held? Disclosure to a requester's counsel of record subject to a claim of this privilege may only be ordered when absolutely necessary. So the facts of this case did not meet the absolute necessary criteria. So documents that are subject to solicitor-client privilege can only be disclosed when they are absolutely necessary to be disclosed. Records subject to a claim to solicitor-client privilege may be ordered disclosed only where absolutely necessary, a test short of absolute prohibition. Different test is not justified for access to information cases. Here the evidence revealed no such absolute necessary. Any records claimed to be subject to solicitor-client privilege should not be disclosed. So you can see that there are few cases where there are few laws, legislations that require to set aside this confidentiality. But that thing should follow absolute necessary criteria. Only there you can do away with. Then fifth exception is legislative exception to confidentiality in the context of law enforcement and national security. So there were few cases like Rackle and Haynes versus Canada, Attorney General, then White versus Ottenheimer, Baker versus Canada, R versus Fink. So privilege is protected under Section 8 of Charter as part of client's fundamental right to privacy. In Labelli, this first case, the court relied on constitutional character of the privilege to strike down legislation. Section 488.1 of Criminal Code, which provided a procedure for determining claim for privilege over documents seized from a lawyer's office under search warrant, because it allowed for the loss of privilege without client's knowledge or consent. So in this case, judge said that a client has a reasonable expectation of privacy in privileged communication under Section 8. But at para 35, judge stated a client has a reasonable expectation of privacy in all documents in the possession of lawyer which constitute information that lawyer is ethically required to keep confidential. An expectation of privacy of the highest order when such documents are protected by the solicitor client privilege. So in these cases, basically the court related this privilege thing with section 8 of the charter, but in cases where the law enforcement or national security requires to do away with this, it is justified, is it valid, then you have right to access any kind of such documents, any kind of such privileges. So there are another cases in the notes related to this national security law enforcement thing that you can read from notes. So special cases. Lawyer-client confidentiality and privilege in the context of withdrawal from representation. Duty of confidentiality does not cease when representation of client ends. It continues. So model 3.7 says, when a lawyer withdraws, lawyer must try to minimize expense, avoid prejudice to client. We read this earlier. Then we talked about R versus Cunningham case in relation to non-payment. So in few cases where a lawyer-client relationship ends and the reason is non-payment of fees, there also this privilege ends, but to the extent that the information disclosure is required. So lawyers may disclose confidential information in order to collect lawyers' fees if lawyers are not getting paid, like in this case, but must not disclose more information than is required. So under this case, this exception, the lawyer-client privileges ends to the extent only that a lawyer can use that information, can put forth that information before court in order to have legal fees from the client. So this you have to keep in mind. So then there is another special case, taking custody and control of real evidence, R versus Murray. So first, let's look into the facts of the case. Kenneth Murray was Paul Bernardo's lawyer. Murray attended crime scene, removed videos that were not discovered by the police. He did this because his client Bernardo instructed him to. So he took took custody of real evidence. He held on to videos for 17 months, did not disclose this to authority. He was charged as a result with attempt to obstruct justice. Eventually, when he was charged, he handed over the videos. He had been refraining from turning them over because the tape supported the position that Carla Homolka was actually responsible for death of two female victims. What was the objective and purpose of Murray concealing the tape? Was it unethical to handle physical evidence without going to police authority? So there was a reasonable doubt as to whether Murray was acting with the intentional purpose of obstructing justice. He was acquitted. Why? Because Murray may have believed under circumstances of the case that he had no legal duty or obligation to disclose tapes until resolution discussions for trial. So here, in this case, when he was charged, he although disclosed these things before the court, he handed over the videos to the court, but this does not affect his solicitor-client relationship. So this is the reason why we are studying this particular thing under the exception. So this was all about our lecture 2. Then there are few important additional cases in the notes. Go through the cases. If you don't understand any case facts or the reasoning judgment, you are always free to ask your queries. So that's all. Thank you and good luck.